To get started, I want to invite the moderator of our keynote discussion and the distinguished speeches that we're going to be having here. He is a member of our organization, and since we started this conference, he's been very instrumental in helping us. And he's also a scholar of conflict resolution here at Mercy College in New York. And his name is Professor Arthur Lehman. Prof. Arthur Lehman, please, can you come up? Can we give him a round of applause, please? And Professor Arthur Lehman is going to introduce our keynote speaker, who is, by the way, my mentor from Sac State in California. Who is one of those who have pioneered the field of dispute resolution around the world, and a well-known scholar in Africa. But he's based and teaching in California. But Professor Lehman is going to introduce him.
Okay, so I'm here basically to introduce and get out of the way Ernest Uwazie, Professor and Chair, Division of Criminal Justice, and Director, Center for African Peace and Conflict Resolution, California State University, Sacramento. And he is going to, I guess, appropriately begin this conference discussing the theme, Traditional Systems of Conflict Resolution. So, Professor?
Good morning, ladies and gentlemen. Thank you very much. It's a great pleasure to be here today. And as I often make the point, such a gathering of intellectual powerhouse and intellectual resource, I often say I learn more from the discourses than probably what I'm able to share with you. I thank ISAM, in particularly President Mr. Uwazie, for inviting me. I've been eager to come to the conference since it started some years ago, and we had the pleasure of hosting Mr. Uwazie when he was doing his master's in France, and he was at our Center for African Peace and Conflict Resolution as a visiting researcher. And I'm glad that he's doing what he's doing, because indeed is part of the partnership, part of the growth of the work of the Center for African Peace and Conflict Resolution at California State University, Sacramento. I apologize ahead of time that I really would have wanted to be here for the entire days of the conference, but I'll have to return tomorrow, to go back to Sacramento tomorrow, because coincidentally, we have a major international conference on genocide at our campus that starts on Thursday. And anybody who knows me and issues of this nature, especially when it concerns Africa, knows that they will not be happy if I'm not there. In fact, they're a little bit worried that I'm not quite there now. We have many visitors from different parts of the world, including Africa, coming. But I look forward to at least the engagement and the discourses today and reading the rest of the conference proceedings lecturing. I was asked to talk about traditional systems of conflict resolution. And I did put together a PowerPoint, which we'll get to in a minute. But as I started thinking more about that, one thing about Scholar, this is work that I have been doing and wrestling with since my PhD days at Arizona State University in Tempe, Arizona. About my first year, second year, looking into the research, figuring out what my dissertation will be, eventually settled on dispute resolution in the School of Justice Studies at Arizona State University. And as I began to delve into the literature, some classic work, Bohannon, Gluckman, Sally Mary Engel, writing to some extent in romantic ways about Africa's traditional methods of conflict resolution. And I say that not only because Africa is the source of humanity, but I think it indicates this notion of cross-cultural linkages and legal borrowings. Because whether it's in Africa or elsewhere, you'll find common linkages, common notions. One particular study that struck me was about the Kpelle, K-P-E-L-L-E, moot of Liberia. That was used as a way of thinking about the concept of legal decentralization or community justice in the United States, in a sense that the formal US legal system has become so complex, litigious, inefficient, and unpopular, to the point that it has alienated the very people that it's supposed to serve. And there were many reasons given for this development. And Frank Sander, late now, then of Harvard University, in 1976, in his address at one of the conferences of American Bar Association, made a point of pointing this popular disaffection or dissatisfaction with the American legal system, formal legal system of courts and cops and corrections. I'm a professor of criminal justice, so we think about the 3 C's, and when I teach, I say we should think about the 4th C, meaning the community. Not just about courts and cops and corrections, but the community. That's very defining. And so Professor Sander, in his address in 1970s, called for a rethinking of the current American legal system. And specifically, he called for the concept of a multi-door courthouse. Think of a courthouse, not just the door to litigation, but a courthouse that has multiple doors. You're definitely going to have a place for litigation, but bear in mind that not all cases that come to the courthouse will fit into that door of adversarial system of justice, the fight between 2 people. But consider the possibility that those that have come to the courthouse are definitely seeking for justice. They're seeking for resolution. Justice and resolution may not necessarily mean litigation. It could mean mediation. It could mean arbitration. It could mean negotiation. It could mean conciliation or combination of methods. Because at the end of the day, human beings are very complex. And sometimes we have conflicting identities. You know, we have this concept of hybridity that we tend to move, especially as disputants, shop around. Professor Sander talked about it in his concept of forum shopping. We shop around when we are confronted with conflict for the one that will be satisfactory to our interest, by and large. And so from his concept of the multi-door courthouse, started in Washington, D.C. and Oklahoma, and in Boston, since that time, we have a plethora of community justice centers or mediation centers throughout the United States. It used to be dominated by non-lawyers, but it's probably in terms of the mediators, but it's not about 50-50 to some extent in this field. And so we come then to the topic to kind of give you a sense of why are we concerned, interested, and the relevance of traditional methods of conflict resolution? It indicates clearly that the more things seem to change, right, the more they seem to be the same, in a way. You probably paid attention. I was listening, I was waiting, very attentively listening to the royal family that came up for the opening invocation. The gorgeous looking woman and the highly dressed regalia of the royal father and royal mother. They came, I don't know what you had in mind. I can see probably some curiosity, how is this going to happen? How traditional is going to be? They walked up here majestically. The royal father barely said, probably had some discussion with the royal mother. You probably was expecting some libation of incantation, of invocation of some sort. And here she stepped forward with him beside, I want to say behind. And did what? Prayed, said a Christian prayer. All right? From the symbols in terms of the dressing and the royalness and so on and so forth, and the prayer, you begin to go, what does that really mean? And then again, kind of reminds me of this concept of Sankofa. Sankofa in Ghana, in Ashanti, the kind of the bird seem to look backwards, but actually projecting forward, reminding us of the importance of the past, the critical nature of the present, and the ability to do what? To project forward. And then again, the more things seem to change, the more they seem the same. But at any point in time, when we talk about tradition, we're talking about something that is very familiar, something that reflects some sense of culture that is an embodiment of people's aspirations, beliefs, values, norms that hopefully will conform with the behaviors and practices, even though we have to allow room for disconnect. That's why we talk about conflict. That's why we talk about crime, right? That sometimes our behaviors, our practices may not quite line up with our best values and norms and beliefs. And we begin to figure out, what do we do when those disconnections occur? How far back do we go to try to restore, to try to preserve, to try to consolidate, to try to conserve and affirm the beliefs, recognizing the frailty and fallibility of human beings to some extent. And so when we talk about tradition, we talk about familiarity, the names, the symbols that we ascribe to match or reflect those beliefs and values. In my part of Nigeria, we refer to the Eze, the king, conflict resolution systems. We talk about Umuada, a group of married women who play a very important role in resolving conflict. The Amala, the elders in the community, the family head, and so on and so forth. And go to East Africa, you look at, say in Ethiopia, and part of it we'll talk about the Shmagilis. Sometimes you use a kind of mediate between parties, families, groups, and so on and so forth. Okay. The Ochemeng, or the Nanas, the kings in Ghana, as the case may be, are very important indigenous systems of justice, not just for conflict resolution, but also preserving law and order and democratic governance or community governance, as the case may be. Or even sometimes when we talk about conflict, it's not just those conflicts that relate to between individuals or interpersonal or intergroups, but also intra right? Or sometimes we have things going on with us, and we're not quite sure what to make of it. We know that there's something going on. And we may go to the Sangoma or the Dibir or any number of the voodoo, so to say, to try to ascertain what the issue may be within us to a large extent. And so when we talk about tradition, again, we're talking about very strong held belief systems that define and shape our social relationship and our own understanding of the world around us. Whether we're talking about it again in the concept of mediation or conciliation in a typical urban United States or in the sense of arbitration or mediation that may happen in remote villages in Africa. We also know for sure that no culture is static. Every culture, every society does undergo change from time to time, however rapid or gradual that change might mean. And when faced with challenges, there is always that human capacity to go back. How was it done at some point? What can we understand from the past to try to make sense of our present crisis or situation? And you probably find out that yesterday was yesterday. It may not 100% reflect today, but it may be 10% of yesterday's experience that you can use to try to solve the problems of today. And what decisions we make today, to a large extent, will determine what next would be, or what our next attempt of behavior. Even in the United States, we talk about the principle of precedence with regard to legal decision making. Once the court has said it is austere decisis in common law, the court have made that decision, it has a staying power, right? Yes, the Supreme Court doesn't overturn precedents easily, but it does from time to time. If you go back and look at even some of the decisions made about civil rights, slavery, and so on and so forth, that were, at some point the court said this was okay, but multiple years or many years later, and the court said no, that was not okay. Even as such a strong, codified, highly instrumentalized system of our formal justice can change. What more about those traditions that oftentimes are very oral, though people understand the familiarities, they understand the symbols and the symbolism, the patterns. What more about them? I guess what I'm suggesting by and large in this regard is the concept of hybridity that I want us to talk about. And again, going back, if I might pick on again on the royal father and royal family, without any disrespect intended, it's that cohabitation, right? Christianity was importation in much of Africa, in Nigeria or other places. But it does not necessarily mean that the people didn't have a sense of relationship with the ultimate. Okay? There's a very strong belief in ancestors, that it means that there are gods that are out there that hover around the earth, driven or represented by our ancestors to a large extent, and that we have to respect those. And usually I'm from Igbo land, southeastern part of Nigeria. You've probably heard this clarion call, Igbo Kwenu, right? You've heard that before, right? And you say what? Igbo Kwenu, you say, hey, right? How many times is it done? Usually done 3 times. Usually 3 times, if you do it well, properly or correctly. It's done 3 times. It's basically calling to us, it's like, good morning or hello, how are you, to get the attention of the group before you make an important statement. 3 times, representing again the ancestors that have died and passed on, and you believe that they need to be respected and honored. The earth we live in, with the spirits that hover, the gods that make us live and do what we do. God, the things that the air we breathe, the water we drink, the food that we eat, and so on and so forth. Agriculture that would produce, and so on and so forth. And then heaven or the future. So by the time you make the three calls, you pretty much have called on all your sense of surrounding, the embodiment, and then the gain of humanity. Okay. And so when we are confronted with certain challenges, we kind of go back and say, wow, where did we lose it at some point? Hopefully, a gathering of this nature will continue to remind us of the importance of those traditional systems that have held sway for a certain period of time, not so much in terms of the practices, although important, but the symbolism, the values that are embedded, the norms that undergird such symbols and practices. Because if sometimes when we deviate in terms of our human behaviors or misbehaviors, we try to kind of go back in terms of how do we get back home? How do we get back home, if you may? Okay. And so I make that point again, human beings are very complex. We tend to shop around for fora or disputing sessions or fora or mechanisms that would attend to our best interests. And I think that should always be the constant search for us. At the end of the day, they tend to support strongly our sense of self, worldview, the society, the environment that shape our social relations. At the heart of it oftentimes, in many instances, is this question, and especially the work that we have been doing for the past 20 years, the Center for African Peace and Conflict Resolution, as we struggle with on two competing ends of the dispute resolution field. If you look at at the core of the traditional African conflict resolution, and there's a sense of Ubuntu, collective interest. And that for this collective interest to be maintained, it is much more super and important than individual rights. Okay. That is a kind of give and take. And you superimpose that international notions of justice and human rights and individual rights and so on and so forth. It's a struggle, especially in the cases of mass atrocities. Okay? You name it. Whether it's in Darfur or in Rwanda, you can go on and on. Do we punish, litigate and punish? Yes, we give you your due process, we convict you, and we kill you, or put you in prison for the rest of your life. Or do we mediate? And so the kind of this struggle, and the really point that I really have made in a way is, for me as a conflict resolution practitioner, when it's like a medical doctor. If you're confronted with an illness, your goal is to try to solve that illness, to cure and heal that person. You may not have much control over those that may have died in the past before coming to you, but you have a responsibility to treat that one person that you have in front of you in order to prevent more people from dying. And so, and you find this tug of war, and to some extent has caused some of the displacement and prohibition by Western-driven legal models over traditional methods of conflict resolution. Do we punish for the 1,000 dead or mediate to prevent the death of another 2,000? Key to the traditional African system of conflict resolution are, again, some of the values that I mentioned before. One of reconciliation, collaboration, consensus building, restorative. We know what has happened, it is wrong. How can we condemn that behavior as strongly as we can, and not necessarily the person? Condemn the behavior, not necessarily the person. Because we know condemning that person has even more negative consequences for the rest of the community, for the rest of the village, for the rest of the people. And bring him or her in terms of reintegration back into society. You will find it to be one that is very highly adaptable, and it's really oftentimes focused on solving problems. Now, if you contrast that with the coexistence of the formal legal system of fines, in terms of the outcomes in many instances, a fine using marriages or intermarriages as ways of resolving conflicts, especially in some wars. Apologies, sometimes the person may be banished. Those of you may remember the case of Okonkwo in Chinua Achebe's Things Fall Apart, right? When they committed the evil, he was banished. Sometimes public shaming, which again part of that condemnation, or putting the person aside for a certain period of time in terms of ostracizing. In the formal justice system, fine, incarceration, death, and the use of the corporal punishment. You can compare and contrast the two outcomes in the formal justice system compared to the typical traditional justice system. In the hybrid processes, and again, referencing the royal family, if I may again, coexistence. And it doesn't necessarily mean that they don't work. They do work. We interchange. We use trials when and where needed. Truth, the TRC, the Truth and Reconciliation in South Africa, Commission in South Africa. Apology, amnesty, power sharing, lustration, meaning at some point we're going to keep some people apart from being part of the government, at least for a while. Don't run for public office for 10 years or forever, as the case may be. And then sometimes you may have security arrangements or peace arrangements, creating new institutions that attempt to deal with the conflicts. I'm not going to bore you with this, in the interest of time, but some data in terms of where we are headed between armed conflict and, though the armed conflicts seem to be on the declining in the past 5-6 years, we'll be seeing some increase. It's not worrisome, but you do have a lot of intercommunal types of conflict that should also be worrisome, because if not checked and properly handled, they have a tendency of rising to armed conflict and wars. And so here, reflecting again of the hybridity that I mentioned, the TRC, we are revealing in South Africa where it was more important to reveal the truth as a condition for healing, or as an integral part of the search for healing, which of course also did have an element of trials to some extent. In Rwanda, the Gacaca transitional justice, there are actually three processes. Rwanda had its own national court, had its traditional court, the Gacaca, and also you have the UN tribunal in Arusha. And again, I attended several of the Gacaca sessions, like Sankofa. At this time, at the end of the genocide, Rwanda had over 100,000 prisoners, suspects. Paul Kagame and the government at that time was under tremendous pressure. And there is no way he was going to try those. At the time, you had less than 20 judges in the country, and about half of that in terms of lawyers. So you have the international community that was breathing under his neck, understandably so. And I know he did suffer quite some political capital, and because one of my former colleagues, late now, Dr. Kimei, who was a compatriot of his in the war against the genocide, disagreed with him on the Gacaca, and basically for them, they should be all tried. But I remember when he came to our campus in 2005, it was a really point of his discussion, the necessity of it. Again, people confronted going back, reimagining what that past was to be able to adapt to the present. In Liberia, and again, a version of the TRC, We're not going to have time to play this video. I would have wanted to say, but again, this is the post-Kenya election violence, 2007-2008, that was mediated by Mr. Kofi Annan at the time, where again, a power sharing agreement between the two warring factors. Zimbabwe in 2008, power sharing agreement between then Mugabe, right? And the opposition party. Again, hybridity in place. This sense of consensus. South Sudan, you have a three-part process as well in place. Within the African Union, this is what really drives the African Union's conflict resolution system, pillar. And then again, you have this multiplicity of structures, both formal and informal structures, recognizing both the traditional and also traditional methods of conflict resolution. Again, hybridity in a way. And this continues reflecting the UN Peace and Security Council Prevention, Management, and Resolution of Conflict. It also has the African Court of Justice and Human Rights, again, part of the pillar of the conflict resolution for the African Union. Okay. That has the Pan-African Parliament based in South Africa, Midrand, actually, South Africa. Mm-hmm. And so, at the end of the day, and I think in interest of time, I'm going to kind of rush through this. The key findings and lessons are that there is at different levels of recognitions of formal and provisions for the traditional systems of dispute resolution, whether in the law or in the constitutions or in the governance structure, or sometimes you have the judges or the courts who would refer cases to those traditional methods or indigenous justice systems. Respective also in terms of continental treaties and different formations. We also find situations where there is some level of governmental interference and control, which does have some political considerations and challenges. You have different levels of efficacy, and one of the questions is how effective are those traditional methods of conflict resolution? There are some are more effective than others, for sure. Depends on where, depends on the type of case, the actors who are involved, and also what kinds of rights are. At the end of the day, what you do find is increasing youth revolt for different reasons. And the presence of alternative dispute resolution, or ADR. I make the point that you may have the formal system to achieve a ceasefire, but you need the traditional system to maintain peace and order. A statement that was made by a lawyer in Ethiopia when we were doing work on alternative dispute resolution some years ago, Professor Elias. He says, the court may issue a legal decision, but not necessarily resolve the conflict. And usually whenever you come to the court, it's usually phrased as a legal question. You address that, you answer that legal question, but that doesn't necessarily mean that the conflict is resolved. Sometimes it's the beginning of the conflict when the court issues a decision. Okay. And the point I made before, the Ubuntu value system, that is very, very important. I did make some recommendations here. With regard to research, looking at what we do with regard to how effective they are in terms of evaluation, providing training is the appropriate training as sort of the work that ISAM does, that is informed by some of the value systems of those cultures, and being able to document properly what we do in order to be able to know the rate of satisfaction or changes through the usage of these traditional or other forms of informal conflict resolution systems Thank you very much for listening. Peace.